The last case set for argument is Village of Dalton versus City of Massillon. It's case number 19AP0027. Both sides are represented by counsel. Each side will have 15 minutes. Are you going to divide your argument?
Your Honor, I was going to go first if it was okay with the court, and I'm basically going to defer to Massillon as far as the argument goes today.
All right, so you will divide your 15 minutes however you like.
Yes.
Use as much time and
yes, Your Honor.
You'll have the balance.
Yes.
And then also let me know as to rebuttal.
I'll be doing rebuttal, Your Honor. I'll reserve 4 minutes.
4 minutes, okay. And I will let you know as you get close to that.
Thank you, Your Honor.
Now, thank you for helping me clarify those issues. The court has read the briefs in this matter. We are prepared to proceed if you are then.
Good morning, Your Honors. May it please the court, my name is Brian Barnard. I am here today on behalf of Ted and Penny Renner, trustees. As the court is aware, and you have read our brief, we have basically sided with the City of Massillon as far as the facts, as well as the legal arguments in this matter. And since we are dividing time, I would like to, at this point, ask the court if there are any questions regarding the brief which we filed. If there is not, I would like to defer and allow the City of Massillon to use the balance of all of the time to fully develop their argument today.
Okay.
Thank you.
Good morning, Your Honors. May it please the court, my name is Jacob Reed, and I represent the appellant, City of Massillon. Your Honors, this case is simply about whether a lease entered into between Massillon and the Village of Dalton in 1998 shifted the obligation to maintain and ultimately replace a bridge which is undisputably on the leased property from the city to the Village of Dalton. Your Honors, the clear and unambiguous language of the lease agreement demonstrate that this responsibility lies exclusively with the Village of Dalton for 3 reasons. First, the replacement of the bridge is an improvement to the land which paragraph 3 of the lease mandates Dalton to pay for at its expense and at no expense to the city. Paragraph 4 of the lease requires Dalton to maintain the entire tract of land, which encompasses the bridge in a clean, safe, and healthy condition. And for the 3rd reason, the indemnification clause in paragraph 5 of the lease clearly states that Dalton agrees to save Massillon harmless from any and all claims of whatever kind resulting from injury to any property. Your Honors, as a threshold issue, a couple of notes about the lease agreement from 1998. One, it is clear and unambiguous on its face. Thus, the court need not look to any other documents, deeds, or anything else to derive the intent of the parties in 1998. The terms are clear, they're unambiguous. You can look at their plain language, their plain meaning, and ascertain the party's intent from the document itself. Also, the lease should be considered as a whole, and the court should not isolate one single word or provision of the document. Rather, they should examine the entire lease agreement from top to bottom to ascertain the party's intent. And also, Your Honors, the lease is a 99-year lease. It is not a typical commercial lease agreement for 1, 2, 5, or 10 years. Rather, it is a 99-year lease which the village actually ascertained for the sum of $1. They don't pay rent of any kind. They receive the tract of land, which again encompasses the subject bridge for 99 years. And also, Your Honors, the lease should be strictly construed against the village because they are the authors of the lease agreement, Your Honors. They drafted it, thus Ohio law dictates that the lease should be construed strongly against them. Your Honors, if you look at paragraph 4 of the lease agreement, it states that the lessee shall accept the real estate in its present condition. Lessee agrees at its expense to properly maintain the area in a clean, safe, and healthy condition. As you note, the provision states that the village has the obligation to maintain the entire area. The bridge that is the subject of the dispute here today is located completely within that entire leased area. Therefore, the village has an obligation to maintain that area in a safe condition as clearly stated by paragraph 4 of the lease. If the bridge at issue here falls into disrepair, as it has and as the parties have stipulated, in such a condition that it becomes unsafe, it is entirely the village's obligation to maintain the area and ensure that it is in a safe condition. You'll note, Your Honor, that the area that the village has leased has been turned into a recreational hiking, jogging path. If you have hikers and joggers that are in that area, and take, for example, the bridge is in poor state and it's dangerous and unsafe as it is, if those joggers and hikers were to go onto that bridge, the entire area becomes unsafe and it puts individuals at risk.
Counsel, I was a little confused about how the bridge actually operates. Is this on just a private drive, or is this a public road, or how is that?
From my understanding, Your Honor, it is a private drive, and as background information, there was a right-of-way granted originally in the 19th century, which I'm sure opposing counsel will try to argue controls here, but again, the lease controls the entire agreement, and it shifts that responsibility. But from my understanding, it's a private drive upon which the renters, who are the property owners, they have a right-of-way over that drive, and the bridge is part of that private drive. As far as I know, it's not a public road. I don't think there's public cars often traveling on it.
Okay, when you mentioned about joggers and so forth, and my understanding was the only thing the bridge adjoined was just adjoined the one property area that I'm not sure I understand how it all works out, but is recreation area to a private individual's home.
Right. Yes, Your Honor, but from my understanding, the path runs along the creek which the bridge actually crosses. Now, joggers, not ordinarily go jogging across the bridge, but it's a recreational area. You have my kids, they might wander off the path. The point is that that bridge is entirely within the leased premises, which Dalton acquired in 1998.
But I guess my question is, it's within the premises, okay, but is it used by the recreational area? Because from what you're saying and what I read in the briefs, it sounds like it's only used by the property owners.
Right, Your Honor, and that is correct. It's probably not often used by the joggers. I was just kind of using that as in the event of something would happen. It is the village's responsibility to ensure the entire area is in a safe condition, as noted by paragraph 4 of the lease agreement. Does that answer your question, Your Honor?
Yes.
Okay.
So at one point in time, Massillon did agree to be responsible for the replacement of the bridge. I think that was in the
96 deed.
2 years later, there's this lease between Massillon and the city, or Dalton. Was there anything specific as to the replacement of the bridge? There wasn't.
There was not the specific word replacement, Your Honor. But again, if you look at the lease as a whole, and if you look at paragraph 2, which states that the lease is for 99 years, paragraph 3, which states that any and all improvements will be made by the village of Dalton, paragraph 4, which states that the village will properly maintain the entire area, and then paragraph 5, which states that the village will indemnify the city for any and all claims whatsoever. If you ascertain the agreement as a whole, it shows that the intent of the parties in 1998 was to transfer all responsibility, all obligations, all duty to maintain and subsequently replace from the city to the village. Is that?
Your argument is look at the entire.
Exactly, yes, Your Honor.
This is how.
Did the lease itself talk about this being turned into a recreational area?
It did, Your Honor. And
So wouldn't all those things you're talking about, wouldn't that relate to the recreational area? I mean, because ordinarily, if you're talking about replacing a bridge, you're not talking about maintaining property in a healthy, clean, and safe manner.
well, the fact is the bridge is within the recreational area. It is part of the leased premises. It is the tract of land which Massillon ascertained in 1996 and transferred the entire tract of land via the lease in 1998 to the village. It is part of it. It is included.
Right, but that doesn't necessarily mean that they transfer the responsibility to replace.
Well, I would argue it does, Your Honor.
I understand what you're arguing,
Sure.
but I'm saying just because you're arguing, regardless of what the lease says, because the bridge is within the recreational area, they're automatically responsible for it.
Yes, Your Honor. And in any event, even if you look at provision 5, the indemnification part of the lease, it states that lessee agrees to save the city of Massillon harmless from any and all claims of any kind resulting from injury to persons or property. Now, we have a claim here. The claim is by the renters. They cannot use this bridge to gain access to their residence. There has been a claim made.
Right, but wouldn't that make more sense in the context, the entire context of the lease to mean, you know, if the runner falls or goes over a ledge, you know, or whatever, and is injured, or a car, you know, gets hit in the parking lot, that Massillon doesn't want to hear about this because they're not responsible for it.
Sure, Your Honor, and that'll be opposing counsel's argument that this applies only to tort claims of the sort you just mentioned. However, just looking at the plain language of the agreement, it states, from any and all claims of any kind. There is no limitation within the contract, therefore you cannot read a limitation into the contract. This lease agreement is a contract, the language is plain, clear, and unambiguous. Therefore, you only need to look at that provision of the agreement without thinking, well, does it apply to tort claims, contract claims, etc. It's any and all claims whatsoever of any kind. Your Honor, in two cases, one out of the Cuyahoga County Common Pleas Court and one out of the 5th District Court of Appeals, precisely held because there was not the precise word to replace in those lease agreements. There was a lessor-lessee relationship. The cases are Statler Arms versus APCOA, that's the one out of Cleveland, and then Andrews versus Schmelzer, which is out of the 5th District. There the lessees claimed because the lease agreement did not include a specific provision that they had to replace, that they were not obligated to replace the subject at issue. For example, in the Andrews case, the 5th District expressly held that the lease term requiring the lessee to maintain a bridge required the lessee to do what was ever necessary to keep the bridge functional, including a duty to replace the bridge. And the court there expressly said that maintain, the phrase maintain, includes a duty to replace.
But that was all in regard to a bridge.
That was, yes, Your Honor. That was a bridge precisely in Andrews. It was a bridge. Your Honors, sorry, I'm checking my time here.
You're at about 4 minutes and 10 seconds.
Yes, sir. Again, I'll just note that the indemnification agreement, in any event, whether you want to construe maintain loosely, it should be constrained broadly and looking at the whole of the lease agreement. The indemnification agreement clause provision settles this no matter what. It says that the village will indemnify the city from any and all claims whatsoever. With that, Your Honor, I'll reserve the rest of my time for rebuttal.
And that would be 3 minutes and 50 seconds.
Thank you, sir.
$15 minutes, of course.
Thank you. Okay, please, the court, Mr. Reed, Mr. Barner. My name is Bob Reynolds. I'm here on behalf of the village of Dalton. By way of background on this, this property lies on the north side of Old Route 30. It's Main Street now in Dalton, but was the original Route 30. The rail line in question runs parallel and north of Route 30. And when this land was acquired by the railroad back in the 1800s, as part of the consideration for the giving of the right-of-way, the landowner wanted not only the right to cross the railway to access both parts of his property, the north half and the south half, but also because there is a creek which runs to the north again of this rail line. So you've got Route 30, then the rail line, and then a small creek, that in addition to reserving an ability to cross the rail line, he imposed an obligation on the railroad to build and maintain a bridge across this creek. So that's kind of the physical layout. You've got 3 parallel lines running east-west. This one private drive running north-south that crosses the railway, crosses the creek, and it provides access to the renter's property, which is to the extreme north in the context of what we're discussing here. And by way of background, the village solicitor for the village of Dalton, Melissa Kramer-Smith, provided an affidavit that was part of our brief for summary judgment that kind of sets out that factual background of the layout. The city of Massillon and the renters have raised basically 3 separate arguments as to the reasons why the village of Dalton should be responsible for the replacement of this bridge. Previously, we were before the court, and there was a procedural issue as to whether or not we had satisfied or answered the issue of whether or not replacement was necessary. I think we've addressed that one after some examination and back and forth. We've stipulated that the bridge is in need of replacement. So now the question before the court is, okay, who's responsible for that? The city of Massillon and the renters have raised 3 separate arguments based on 3 separate paragraphs of the lease agreement. The first is paragraph 3, which includes language about the improvements. Paragraph 4 is the maintenance provision. Paragraph 5 is the indemnification provision. I'd like to address each of those in order. Paragraph 3, the pertinent language is, any and all improvements will be made by the lessee at no expense to the lessor. In their brief, the city of Massillon has argued that this requires Dalton to make improvements. Respectfully, that is not the case. It just says that if Dalton does make improvements to the property, they will be at Dalton's expense and Massillon's to be held harmless. Next in their brief, Massillon argues that Dalton is responsible for any and all improvements at no expense to Massillon. That's not correct either. It just says that if you make an improvement, it's your responsibility. The real question is this bridge an improvement to the property? And the language talks about...
Wait, do you concede that if it is, then it is in fact Dalton's responsibility?
I will not. I will not. But I would argue it's not even an improvement to this property. An improvement does enhance the property. It adds value to the property. This does not do that. Can you imagine in your home if somebody came along and said, oh, by the way, we're going to build a bridge across your property. It's not going to serve your property. It's going to allow your neighbors to get across your property. That's not an improvement to your property. It may be an improvement for the neighbor's property, but it doesn't benefit your property. That's why in eminent domain cases, the government's paying for that right to put a street, to put an improvement of that type across your property. And that's exactly what took place here. This was not an improvement that was put on to serve the interests of the railroad. Didn't serve the purposes of the city of Massillon, and the city of Massillon acquired it. Doesn't serve the purposes of the village of Dalton now. This was consideration that the landowner demanded upon for the railroad in order for them to exchange fee ownership of this right-of-way. And again, I use that right-of-way kind of generically. This is a fee ownership issue here, but it's the path where the railroad foreman was located. Massillon argues in their brief that this bridge enhances the appearance and utility of this property. That part escapes me. What about a bridge across your property enhances the appearance of it? Or the utility for you if it's used to access somebody else's property? This bridge is a burden on this property, and the ability of the renters to cross this property, and it's certainly something they're legally entitled to. Nobody is questioning that the renters are entitled to the benefit of the bargain made by their predecessor, also named Mr. Reed, I believe, 100 and some years ago. There's no question that they're entitled to this right-of-way and they're entitled to this bridge. The question is, who's obligated to provide that for them?
How much is it going to cost to replace the bridge?
I think we've seen various estimates around. I think the figures are $100,000 or something of that nature. I mean, it's a fairly substantial bridge in the course of, in the context, I suppose, of what we're talking about for just a driveway, because the ravine that it crosses is not particularly wide, but it's fairly deep.
Did either side ever look at mediation for this?
That was not discussed.
Well, you know, we have a reamped,
For this part. Go ahead.
we have a reamped mediation program that we're being very successful with. I think it might be nice for the parties to look at that.
And you could do that after argument, if you both decide that that's what you want.
That's
to
certainly
Just want to bring it to your attention.
All right, back on the clock.
Thank you. That pretty much ties up the paragraph 3 arguments. If I could then skip ahead to the paragraph 5 argument, because again, I think that goes away fairly easily too. That's the indemnity provision. And it's worth noting here, again, the court noted we have this 1996 deed from the railroad to the city of Massillon. Then 2 years later, we have the lease from the city of Massillon to the village of Dalton. The indemnity language in those two documents is identical, word for word. Clearly, there's an intent that whatever indemnity obligations the city of Massillon took on through that deed were being passed on to the village of Dalton. And that language is, lessee agrees to save lesser or harmless from any and all claims of any kind resulting from injury to any person or persons or property. And the city of Massillon tends to leave that clause out, that last clause of resulting from injury to any person or persons or property. And in fact, in their brief, they say, they insert the word including claims arising out of injury to persons or property.
Counsel, I think you're not disputing that the city of Dalton is responsible for maintenance.
Correct.
Okay,
Well,
go ahead.
you know, that word maintenance is loaded, so I do want to address paragraph 4.
Okay, but let me just continue on with this thought, if you don't care.
Yes.
So you're talking about the indemnity, and you say claims of injury to any property or person. Okay, let's say that the bridge, that the renters are crossing the bridge and, you know, they're just walking across it, and, you know, their foot slips through and they break their ankle. Would they go after Massillon or would they go after Dalton?
That's an interesting question.
That's why I asked.
There certainly would be, if they went after Dalton, we'd certainly have a third-party claim in there against the city of Massillon for their failure to take care of, you know, we'd be back to the issue before this court.
But there's nothing in that lease that you, not you personally maybe, but that your city authored that says this is not going to include anything dealing with the bridge.
Correct.
And wouldn't that have been your burden to do, if you wanted to make sure that the bridge wasn't included?
In hindsight, it's certainly something that should have been done. And I think both, obviously we're dealing with the situation here where both sides are wishing that there have been issues addressed in that a little more clearly than they have. But that's often the case with contract interpretation cases, is why didn't they spell this out more clearly? But anyway, with regards to paragraph 5, it is specifically limited to claims arising from injury to persons or property, and that's not what we have here. I would respectfully submit that the real issue here is whether or not this is covered by the obligations in paragraph 4, which includes the maintenance obligation. That is a very, in the 1998 lease, that is very short and concise. It's 27 words. Lessee shall accept the real estate in its present condition. Lessee agrees at its expense to properly maintain the area in a clean, safe, and healthy condition. Massillon advancing the argument that the intent of that paragraph was to pass on to Dalton every one of the obligations that Massillon took on in that 1996 deed. Those are spelled out in paragraph 6 of that deed. And if you've taken a look at this, that's 367 words worth of spelling out exactly what the city of Massillon is responsible for. And if you've seen railroad deeds in the past, or ever had to deal with them, it's fairly standard language in those. They throw the kitchen sink at them, saying, you are responsible for everything. I respectfully submit that if it was the intent of the parties to pass that obligation on to the village of Dalton, they could have done so. Just like they did with the indemnity provision. The indemnity provision was copied word for word. If they wanted to pass all those obligations on to the village of Dalton, they could have done it by either repeating the language word for word like they did with indemnity, or they could have incorporated it by reference, saying, whatever obligations we took on in this 1996 deed, they're yours, village of Dalton. That didn't happen. Instead, they just said, your obligations are to keep it in a clean, safe, and healthy condition.
So is there any evidence as to, because nobody seems to be contesting that Dalton presented the lease to Massillon, right?
It was, the lease was prepared
That's
by
what I'm
the
saying,
Dalton
yeah.
solicitor.
But you seem to be saying, well, they should have done this, and they could have done this, they could have done that. So did they, and you said they presented that language right from the prior deed, the indemnification.
Correct.
So was there any evidence, because this was summary judgment, I know, but was there any evidence that there was a give and take and that different language was proposed by both parties?
There's no evidence on that issue.
Okay. Thank you.
So again, we believe that there's a clear intent there not to pass on all the obligations that the city of Massillon had acquired. And again, given the nature of the arrangement, that makes sense. There's been quite a little bit of talk about a 99-year lease. In the brief, the city of Massillon calls that lease as a transfer of the land to the village of Dalton. Well, that's really not the case. Anytime the land would stop being used for recreational purposes, Massillon's got the unilateral ability to terminate the lease. So it's not a true 99-year lease in which all rights and responsibilities are given to this village of Dalton in the way of ownership. Instead, it's a limited purpose lease for a limited period of time in the event that purpose is not fulfilled. Several cases have been cited defining about whether or not replacement is included within the word of maintenance. All I'd say is there's certainly a diversity of opinion based upon the language of that particular lease and how it's applied. The Schmelzer case that was cited with the oil and gas lease, in that one, I would point out that this was a bridge that was built by the lessee for their own purposes. Now, the lessor was given the right, or contractually had the right to make use of that, but that was the lessee's bridge that served them. In this particular case, this is a lease that a bridge was on the property that was inherited. Again, it was an encumbrance on the property, burdens the ownership of the property, and
How would you distinguish Statler Arms, which your opposing counsel raised, because it involves a 99-year lease, I believe? They looked to the length of the lease to determine who had a duty to repair, I believe.
yes. Again, I tell you, it's pretty much based upon the specifics of the lease obligation. Again, in Statler Arms, and also I think in the Mock case that's kind of in there as well, they're talking about repair of something that serves the interests of the lessee. In the Mock case, I know it was a roof. Statler Arms, I think it was a parking area. Again, in those cases, you're talking about a part of the lease premises that serves the interests of the lessee. It is an improvement in those cases. Those things clearly qualify improvements because they serve and benefit the property. Here we're talking about something that's not an improvement to the property, that's not being used by the lessee, that doesn't benefit the lessee.
With that, your time is up.
Thank you.
Thank you. Now, rebuttal, you will have 3 minutes and 50 seconds.
Thank you, Your Honor. May it please the court, just a few points on rebuttal here. Regarding the cases you just cited, I would just like to mention the Mack case. In that case, it was a 5-year lease. And the court looked at the fact that the lessee would have a duty to replace the roof, but then in a few years down the road would have no possession of the property whatsoever. So in this case, we have a 99-year lease. If Massillon ever gets the property back, it would not be until 2098. And I don't know how long bridges last, but if the bridge is replaced as of today, surely whether the village of Dalton is using that bridge or not, it is on their leased property. And the city of Massillon, well, they're out of possession, they're out of control, they haven't been in possession or control, they have nothing to do with the property whatsoever, and they haven't since 1998. And they will not have anything to do with the property until 2098. And Your Honors, I just want to address Judge Carr's question to opposing counsel. You asked whether if one of the renters were injured on the bridge as they were crossing it. whether Dalton or Massillon, who should the renters go after? Well, the question is undeniably that the village of Dalton will be liable. You can look at the indemnification provision of the lease from any and all claims. Even if you want to take opposing counsel's argument that it only applies to tort claims, in that situation we have a personal injury, the village of Dalton is obligated to indemnify the village of Massillon. And it even says further on in that provision that in the event lessor is made a party to any such action, upon written notice to lessee, lessee agrees to take over the defense of and pay and liquidate any judgment resulting from that action. That's specifically in the contract. And again, Your Honors, I would just like to remind you, opposing counsel said that we have 3 arguments as to ascertain the intent of the parties in 1998. We do not have 3 separate arguments. We have 1 argument, and that argument is that the intent of the parties can be derived by looking at the whole lease agreement. That includes paragraph 2, paragraph 3, paragraph 4, and paragraph 5. Those paragraphs of the lease agreement show the clear intent of the parties in 1998. The clear intent was that the city intended to give all obligations to maintain, replace, take care of, restructure, whatever it might be, in 1998 from Massillon to the village of Dalton.
But that's not what the city said, right? That's not what the city of Massillon said in this lease. It didn't say that. It just talked about keeping it in a clean and healthy manner, a safe, clean and healthy manner. It didn't talk. It could have definitely. I don't know. The argument is that Dalton prepared the lease, but you didn't have to sign it. I mean, those items could have been contained in there so that there would be no disagreement as to who's responsible for the bridge.
And that might be true, Your Honor, but again, that's if you narrow down and look just at paragraph 4, right? Our argument is you got to look at the whole lease agreement. And again, I will remind you, the village of Dalton did prepare this lease. They presented it to the city of Massillon, and the city of Massillon signed it. I was 5 years old in 1998, so I'm not sure.
I'm surprised you were even born.
But again, Your Honor, I would just remind you, this is a 99-year lease that the city intended to give any obligation to the village. They were out of possession, out of control, and you can clearly see their intent from the whole face of the 1998 lease, Your Honor. And if there are no other questions, that is all.
I would just, this is not with the time or anything, but I would just remind you about our mediation program, just as I talked to the others.
Yes.
Especially if you have not even looked at it yet. Thank you.
So the way that works is if you are interested, contact the court. The mediator will get involved in the case. Now, I will tell you that it puts what we do on hold while you're mediating the case. So if you're going to do that, do it fairly quickly so before we get started on it.
And the other thing is, sometimes the mediator will contact the parties and say, look, I've reviewed this, and I think it might be appropriate for mediation, so.
Okay.
So don't be surprised if you get a call, too.
Sure.
All right, that having been said, I want to thank both of you for being present and providing the court with these arguments. We always enjoyed hearing from counsel, so thank you for that. The court will take the matter under advisement, issue a decision in due course. The clerk of courts will mail a copy of the court's decision to counsel on the day it's released. And as you probably know, the opinions are also posted on the Supreme Court of Ohio's website. Again,